Within days after starting your medical malpractice lawsuit, I get a call from the senior partner in the defense firm that is now representing the various doctors whom you have sued. He calls me and he asks me, he said, "Hey, Gerry, how much do you need to settle this case?" You want to know what I said? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I can say one of two things that is still going to be respectable and allow me the opportunity to have wiggle room as this case proceeds through litigation. You want to know what this is all about? Come join me as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, so here's the scenario. We started a lawsuit on your behalf because a medical expert confirmed that your doctors were careless and caused you significant harm and injury. And now, shortly after starting your lawsuit, the defense attorney who has now been assigned to represent the various doctors whom you have sued, whom I know from other prior cases, a very good, very well-respected attorney, very experienced attorney, calls me up and says, "Hey, Gerry, I've just now gotten this case. I see you are now suing the following 3 doctors and the hospital. How much do you need to settle this case?" First of all, why would the defense lawyer be calling me within days after starting this lawsuit? Is there any possible way he's going to truly know what the value of your injuries are? Is there any possible way this doctor has done a detailed and thorough investigation about what occurred in your case? Is there any possible way to think that this attorney has gone ahead and met with various medical experts to discuss the details of what was done in your particular case? The answers are no, no, and no. So if that's true, why would he be calling me up to say, "Hey, how much do you need to settle this case?" I'll tell you why. This call is a probe. It's a probing call. It's an initial call that says, "Hey, just want to let you know, I'm now your adversary. I'm now your opponent on this particular case once again. And I want to know from you, what's in your mind? What do you think this case is really worth at this point?" It's a probing call to learn details and information from me at the very beginning of the case, because at this point, this attorney knows virtually nothing. All he knows is what he's looking at, which is the document that started the lawsuit called a complaint. And in the complaint, in many instances, we go ahead and itemize certain details about what occurred, but then many other details are left vague, intentionally left vague. And then, as the case progresses, we have to get very detailed and very specific about what our allegations are against each and every person that we have sued. But go back to the question that I asked at the very beginning. What would prompt this defense lawyer to pick up the phone and call me within days after learning that he's now representing these doctors in this medical malpractice case? He wants to probe to see what this case is about. He wants to probe and see if I have an idea yet as to what the value of your injuries are. Now, my response alternatively could be, listen, here's a brief summary of what this case involves and why your doctors are all responsible for my client's injuries. We believe that this case is worth not only the full value of each of your client's insurance policies, but much, much more. Now I briefly go through and explain to him why I believe the injuries are worth substantially more than what the value of his client's insurance coverage is. And now, why is that important? Because he's going to take that information, put it in a report, send it off to the insurance company, and now they will go ahead and set what's called reserves. When setting reserves, it's basically an opportunity for the defense to turn around and say, you know what? We think that if this case goes the distance and goes all the way to trial, we think we're going to lay out X thousands and thousands of dollars during the course of this litigation. And if the plaintiff, if Oginski's client is successful, we think this case might have a true value of $10 million. Now they will go ahead and set aside a certain amount of money for the purposes of protecting their doctor, protecting the hospital that has been sued, in the event we are ultimately successful. So they go ahead and do that on their books. Whether or not they actually transfer money, it's highly unlikely, but the reality is that they have to create some idea and give some initial expectation of where they think this case will ultimately go. That really has no bearing on what they intend to do during the course of the litigation or whether they intend to make an offer, most often. But what they're trying to do is trying to assess risk at the very beginning. If after this conversation I have with the defense lawyer, they go ahead and say, you know what, this case is worth only $10,000. And now, after 2 years of litigation and going to trial, we get a verdict of $10 million. They're going to be quite upset because they will have totally misread this case. They had not set aside sufficient funds necessary to go ahead and protect their clients and protect themselves. In that instance, somebody's going to have to answer the question, why did you assign only $10,000 in reserves to this particular case? So, one of the reasons why the defense attorney will call me up to say, hey, Gerry, I just got assigned this case. Can you tell me what it's about? Now, briefly, I will explain what it's about. And if the defense turns around and says, you know what do you think this case is worth? What are you looking for? Those are two different, distinct questions, what I'm looking for and what the case is worth. But putting that aside for the moment, when I tell the defense lawyer that this case is worth far in excess of the insurance policies for each of the doctors and the hospital, now it raises red flags, it raises antennas that says, okay, this is a substantial case. We need to be aware of it and pay careful attention to it because it may require significant resources as we go through the litigation process. So don't think for a second that just because the defense lawyer has now asked me the question of what I think this case should settle for or what the case is worth, that means in any regard that they're going to make an offer or that they have money available to offer or that they're even interested in trying to settle this case prior to trial. So why do I share this with you? I share this with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.